Button there. Thank you, sir. I do have an amendment that's being circulated around, and what I'll do is I'll try to summarize what the amendment is intended to do and what it provides. First of all, I want to thank those that have come here to testify today, and I want to go back to what Pastor Henson said, is that what you do to the least of us, you do to us. And I don't believe that in anybody's eyes, when children are entrusted to our school systems, families are entrusting us and those teachers to look after those children. Unfortunately, we cannot legislate a kinder world. We can't require our state and the people in it to be nice to people in the communities. But we ought to do everything we can to make sure that when children are in our schools, they have a safe and welcoming environment for them, regardless of how anyone else sees them. And what my amendments attempt to do is to address the concerns I had regarding this bill and focus it on the issues. Number one, it leaves intact the enumerated actions to help instruct teachers and the other school employees regarding what they should look for. Number two, there's the bill, and I'm not going in number of the amendments, but in purpose. Number two, the bill, as in its current posture, says that there should be training of the teachers, but doesn't provide any guidelines for those trainings. What the amendment does is provide that at least 4 hours of the existing 3 days of in-service training now be devoted to instructing teachers and other school personnel what to look for. Because we've had enough unfunded mandates come out of this body. What we need are mandates that say, we want you to do something and we want you to devote the necessary time to make sure you do it appropriately. What the amendments also incorporate is a removal, I believe, of unnecessary language as it relates to bullying in the context of who would be considered a victim here. Bullying occurs in the schools to our children, and the children should be the focus of the of a bill that we pass. So what the amendment does in many of these instances is remove a reference to school employees, not to remove them from stopping bullying children, because if that's happening, it should stop immediately. But it removes the context of, is there a situation where a student can bully a school employee, or of teachers bullying each other? There's already existing policy, employment contracts, and other law that takes care of the relationship of peers in a workplace. If a student is acting inappropriately towards a teacher or school employee, there's already law and policy in effect to deal with that relationship. What I believe the focus needs to be is on the student and who is mistreating the student. If it's other students, if it's teachers, administrators, or other school employees, that's what the focus is. That's what we should be focusing on. And that's what these amendments are intended to do. And lastly, what it does is remove the list of motives. You know, we have a list, and everybody that came to the table, and I started making a list, whether it was orientation, sexual orientation, diabetes, autism, whatever it is, when you start making lists of the motive of somebody, you're going to leave something out. And when you leave something out, you've created a loophole. You know what? I don't care what your motive is. If you're bullying kids, you ought to be held accountable, and you ought to be, that action needs to be addressed right then and there. So if you leave in the listed enumerated actions and you take out, I don't care what your motive was, don't do it in our schools. I think this bill is more refined. is better opportunity to overcome challenges to it and accomplishes the intended result of making sure that children across this state have the opportunity to attend schools in an environment that is both safe and welcoming and free of bullying. And with that, I'll be glad to answer any questions regarding the various amendments that are spelled out in here. The only thing this amendment doesn't do, and it wasn't done just because I couldn't figure out a way to do it in here, is provide some teeth for what happens when there are instances of bullying that don't get reported. And as soon as we can figure out a way to hold people accountable when they're aware of these situations and don't report it, I'll be the first one to bring that legislation. So that is what these amendments are intended to do, and I'll be glad to answer any questions regarding those.
Thank you, Representative Thompson. Does any committee member request that Ms. Jolly read the amendments? Do they need to be read? Okay, seeing none. Representative Smith, you have a question on the amendment.
Yes. Give me your explanation again of removing the enumerated list, because it says not limited to. So it's not necessarily that this is an all-inclusive list.
Thank you, Representative Smith. I'm removing not the enumerated actions, but the enumerated motives. When you get into the part of the bill that deals with, and this is on page 3, starting on line 4, a reasonable person under the circumstances would perceive as being motivated by. I don't care what your motives are. Bullying is an action, not a motive. And so I believe when you start listing particular reasons for the action, I don't care what those are. We shouldn't run the risk of leaving anybody out. If the actions are bullying and the actions are affecting children, why start a list that would be inconclusive? Because by its very definition, it's an enumerated list. What happens to the family who has a child that is entrusted to our school system that doesn't fall under an enumerated list? Are we here next year and the next year and the next year to add to that? I say take it out because it's the action, not the motive, not what's in the person's mind. It's what the person's doing that constitutes bullying.
Are you aware that this is very similar to what we already have in place? It's already no list, and bullying occurs no matter what. So what you're doing is still not giving a definition to the effects of bullying and to who is being bullied at a school. And if you never do that, you will never, ever have a bill that will stop bullying in our schools. And that's already been testified, that once the enumerated list are put in the bills, that bullying has gone down. As I mentioned to you, Governor Christie has the most stringent, and it's amazing that the lawyer talks about constitutional amendment. He has the most stringent anti-bullying bill in the country right now. A Republican governor who looks at not only what you talk about, and we don't even have criminalization in this, and it was mentioned it's criminalization. We're not saying bullying is a crime here. We're saying that we want people to recognize it and be incentivized and be able to go in and have interventions on students who are being bullied. We're not saying it's a criminal act. The other bill did, that was coming through the legislation, said it was a criminal act. But my point is that with a Republican governor already having the most stringent bill out there, which a lot of this came from his bill, except for the fact that he fires people who don't report it. He does things other than what we have in our bill. But he has a continuous training opportunity for people in New Jersey. So what I'm saying is that we mimic this to look at a bill, and the enumerated list is also in there. I want you to know that. So if it's unconstitutional across the board, then is it unconstitutional in New Jersey? Is it unconstitutional in Georgia, which just put it in place? Why are we saying it's unconstitutional here? Well, because it's not unconstitutional.
Representative Smith, you haven't heard me say that enumerating a list is unconstitutional. What you've heard me say is that I'm far more concerned with the action than the thought. I'm far more concerned with what you do rather than why you do it. And it's the action that every single parent and student has testified here today. That was the problem, not the motive. It's the action. So what I would suggest to you is that what we have in place is a good start. It's not good enough. I like your bill. I like aspects of it. That's why I didn't take out or include in this amendment anything to do with what you're adding regarding the purposes to stop harassment, intimidation, and bullying, and any of the enumerated actions there. I think that's a very positive step in the right direction. I think you're right to say there should be training. I don't think you go far enough. That's why I say require at least 4 hours of training on the list you have in this bill. Where I have a problem and where I think we disagree possibly is not that there shouldn't be bullying, but why should we limit it to what's in the person's mind? Because it's not an intent, it's the action. I can promise you not one single person or one parent who's spoken here on behalf of a child would tell you, I want you to stop thinking about being mean to my child. They want you to stop being mean to that child. They want you to give that child an opportunity to learn. And I can't make that home safe. I can't make the neighborhood safe. But I think these amendments to this bill help make our schools a better environment and stop bullying across the state.
Well, I'm going to object to the amendments anyway. So.
Okay. We have another question from Representative Broadwater.
I'm just going to ask the professor just to weigh in on the enumerated list, and are you aware of any challenges to other states that have adopted this yet, or are there any? You mentioned the most recent court cases you're aware of, but if you can just touch on that, please.
The New Jersey statute has not been challenged yet. It's a new statute, so it hasn't really been implemented that much. And I'm not sure. I'd have to sit down. I wish Representative Smith had an attorney who had looked at this from a constitutional standpoint. But I have not sat down with the New Jersey bill. I know she says some of this came from it, but I've done a lot of drafting, and sometimes that can be the worst thing when you pick little pieces out of a statute. I mean, it may have, for all I know, an exclusion for religious and political speech, for example, in it,
Okay.
which would then.
Representative Broder, I've been pointed out that I'm out of order by allowing her to answer a question on this, so I'm going to have to cut you off on that. I'm sorry.
I wasn't out of order,
Yeah,
was I?
I was.
Okay.
Okay. All right. Representative Smith, are you still? Okay. All right. Representative Thompson has brought an amendment to the floor, of which Representative Smith has opposed. Do we have any questions on the amendment? Okay, then we'll vote on the amendment. Ms. Jolly, would you explain exactly what we're voting on, please, ma'am? I've got Jones push, sorry.
Right. Mr. Chairman, members of the committee, the amendment offered by Representative Thompson has been explained, and the objection by the author has been stated. So if you're in favor of the amendment by Representative Thompson, you vote yes. If you are not in favor, you vote no.
Okay, Ms. Snowden, please call the roll.
Representative Carter?
Yes.
Yes. Representative Bishop? Representative Broadwater? Yes. Representative Burns? No. Representative Carmody? Yes. Representative Champagne? Yes. Representative Edwards? No. Representative Henry? Yes. Representative Hollis? Yes. Representative Jefferson? Yes. Representative Landry? Representative Price? No. Representative Richard? Yes. Representative Schroeder? Representative Shadwin? Yes. Representative Smith? No. Representative Thompson? Yes. Representative Williams? No.
The amendment passes 10-5. Representative Smith, you can close on your bill.
Members, rather than you degrade a bill that was meant for safety for children, which is what you've just done by this amendment, I am pulling the bill. Thank you.
Ms. Smith moves to voluntarily defer the bill. Okay, is there a motion to adjourn?
No, you can't. No, you can't.